Hi guys, welcome to another episode of Attorney Vlogger, Law for the Everyday Layman. Today we take up part 9 on the law of sales and we'll talk about the risk of loss or deterioration of the thing in a contract of sale as well as the effects thereof. Okay? So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? Now, let's first talk about loss. When we know that a thing is lost when it perishes, goes out of commerce, or disappears in such a way that it cannot be found, or its existence cannot be known, or it cannot be recovered. Okay? Now, I also want to talk about other principles. I want to remind you of the general rule that the sale is a title and is not a mode. Okay? The sale by itself, the contract of sale by itself, is not what transfers ownership from the seller to the buyer. No, okay? It is delivery that works as the mode of acquiring ownership, no? It is through delivery that ownership is transferred from the seller to the buyer. And finally, please remember the 3 stages in the life of a contract. We have the preparation or negotiation stage or policitation. We also have the perfection stage and the consummation stage. Okay? Now, let's first talk about the preparation stage, namely before perfection of the contract of sale. Now, if a thing is lost before the contract is perfected, then we follow the general rule, which is res perit domino. Res perit domino simply means that the owner bears the loss. Okay, this is simple enough. Okay? Whoever is the owner at the time of the loss will bear such loss, okay? And before perfection, since the thing has not yet been delivered to the buyer, then the ownership is still with the seller. So, in other words, the seller is the one who bears the loss, okay? Now, at the point of perfection of the contract, the rule is still a res perit domino, okay? The owner bears the loss, okay? Pursuant to Article 1493, if the thing is entirely lost, then the contract is without effect. Why is the contract without effect? Because one of the elements of the contract is missing, namely the object. So the contract does not come into being, it is ineffective, okay? Then if the thing is only lost in part, no? Then the buyer may choose either between withdrawing from the contract, okay, or not proceeding with the contract, or he can choose to demand the remaining part while paying the proportionate price, okay? And after delivery, then still we apply res perit domino, the owner bears the loss. And here, since delivery has transferred ownership from the seller to the buyer, then now the buyer is the owner, and as such owner, he now bears the loss, okay? Now, the tricky part comes at this point between after the contract has been perfected and before the thing has been delivered, okay? This is where authors diverge in their opinions. According to Villanueva, this divergence may be caused by the Code Commission, no, the Civil Code Commission's effort or attempt to incorporate common law concepts and concepts from the Roman law with the modern civil code provisions existing in our code today, no? So there may be a few irreconcilable differences among the articles in the civil code. So what rule do we follow? Okay, there are 2 views espoused, okay? But before we go into that, the general rule is simple, no? As with any other contract, if there is a stipulation, we just follow the stipulation. If the parties stipulate who will bear the loss after perfection and before delivery, then that party so stipulated will bear the loss. It's that simple. The diverging views, no, the first view and the second view, come into play when there is no stipulation, okay? Now, I will not confuse you by discussing both views, no. I will just discuss what I believe, no, to be the better view. And I say that this is the better view because this is what is concurred upon by majority of the authors like Villanueva, Baviera, and Jurado, and Tolentino. Okay? Now, this view, in case of after perfection of the contract and before delivery of the thing, is that the loss of the thing is borne by the seller. Why? This is the more equitable view to take, because before delivery, the buyer is not yet the owner. Okay? And since he's not yet the owner and he will never be able to receive the thing because the thing is lost, then it will be unjust and inequitable to make him pay for something that he will not receive. Remember that the sale is a reciprocal obligation. One of the parties will have to perform his part and the other will perform his part. If one of the parties can no longer perform his part, it will be the height of inequity to make this other party also perform his part when the other cannot. Okay? So the more equitable view is that the seller will bear the loss if the thing is lost after perfection of the contract but before delivery. Also, this is the view that will most reconcile the articles 1480, 1538, and 1504, which embodies the latter one, 1504, embodies the principle of res perit domino. Okay? Under this view, those three articles are now held consistent. Okay? The only inconsistency probably will be with Article 1189 on deterioration. Okay? But my advice when it comes to if you are asked a law question, whether you be an accounting student or a law student, if you are asked a question where the authors are divided, just pick one side. Okay? Until the Supreme Court or legislation has given us a definitive rule which one to follow, then pick one. Okay? Pick one and just defend your answer using the basis given by law. Okay? If you're picking the first view, then of course you defend your answer. No? You have to cite the justifications for choosing that first view. Okay? But again, just to reiterate, my view on the matter is that after perfection and before delivery, the goods are at the risk, the loss of the goods are at the risk of the seller because the buyer is not yet owner. Okay? The buyer is not yet the owner, and therefore, following res perit domino, he will not bear the loss. Okay? Now, when it comes to deterioration, we follow Article 1189, specifically paragraph 3, in the rules of obligations and contracts. Okay? Now, the rule here is that in case of impairment of the thing, then such impairment or deterioration will be borne by the buyer if the thing deteriorates without the fault of the seller. Okay? But if the thing deteriorates through the fault of the seller, no, he is at fault. Okay? Then the buyer may choose either specific performance or rescission, and he may claim damages in either case if so warranted. Okay? So that's it for loss and deterioration of the thing. Just remember, no, the key here is res perit domino. Okay? The only problem you will have to deal with is the situation after perfection and before delivery. Otherwise, for all other scenarios, res perit domino. The owner bears the loss. Okay? So that's it for part 9 on the law of sales. I hope to see you in my next episode. See you soon. Bye.